If there's an investigation made against the quote-unquote employer, and either the CHRO examiner releases the employee to pursue a lawsuit against the quote-unquote employer, is it the intent of this, or for legislative intent at least, will that employee, at least under the CHRO standards, also be allowed to bring other claims in court once being released by CHRO as an employee? Through you, Mr. Speaker.
Representative Terzi.
Thank you very much, Mr. Speaker. As we mentioned in Amendment B, we are dealing with the Commission on Human Rights and Opportunities section. We are dealing with complaints, review, dismissal, mediation, findings, attempt to eliminate discriminatory practice, discrimination. Another citation, 46A-82, you can find is discriminatory practice complaint filing. Another cited section is 48-86A, notice concerning complaint. 46A-64C, discriminatory housing practices are prohibited. 46A-81E, sexual orientation discrimination is banned, including for housing. 46A-100, discriminatory practices. This does allow for a cause of action upon release from the commission. In 46A-44, we deal with complaint, certification, hearing, settlements, default. In 46A-89, we deal with petition for relief regarding discriminatory employment practice, discriminatory housing, and public accommodation practices. So, sir, since not one word here has to do with other kinds of complaints except for discrimination, I would say the answer is no.
Representative Shaban.
Thank you, Mr. Speaker, and I appreciate the gentleman providing that answer, because frankly, on the face of the bill, that is not obvious, and I think that is a huge hole in the public policy statement and legal statement that this bill seeks to make. Now, unfortunately, when you get legislative intent, which is always good to have, but when you get legislative intent, the only time you actually get to the legislative intent, if there's a lawsuit and appeal and some lawyer or some litigant actually has the time, energy, and resources to drill down on the legislative record to try and determine what this statute does. So I suggest that for whatever this task force is going to continue to do, frankly, I think this bill is half-cooked. I think it's half-cooked because the gentleman's right. If people shouldn't be discriminated against, especially if they're working in someone's home, that's bad behavior. I think we're all against that. And if there's a technicality in the law that prevents them from being protected by the law, we should fix that. But if the fix is going to create more of a problem, then we have to do some more work on the bill. I think this bill, again, is half-cooked. I appreciate the gentleman giving the responses. I'm going to continue to listen to the debate, but as it's currently constructed, I'm not sure I could support this. Thank you, Mr. Speaker.